Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Labenz. Today we're going to talk about how to prepare for trial if you have a post-decree or post-order modification or enforcement case. We're going to talk about how to get your case set for trial if the judge doesn't set it for trial and you're like, hey, I need a trial set. We'll talk about how to do that. We'll talk about your list of witnesses and exhibits, the notice of issues, the pretrial statement, the trial outline, which is optional. You don't have to do it, but I do recommend it. And then what to do if the judge orders you after the trial to lodge a proposed order with the judge's findings and orders. So let's start with how do you set a case for trial? This is under Rule 77. The court could set a trial on its own. That could also happen at a resolution management conference or a scheduling conference. But if your case hasn't been set for trial and you're ready for a trial date, then you can file a motion to set. It needs to include the date by which your case will be ready for trial, the names, addresses, and telephone numbers of the parties or their attorneys who are responsible for the conduct of the trial, whether the case is entitled to preference for trial because legal decision-making or parenting time is at issue, and the estimated time for trial. So here is the set form for Maricopa County, and you'll see that this does match up with the rule. So when's the case going to be set for trial? Information about who's conducting the trial. If your case has preference because legal decision-making and or parenting time are at issue. Whether or not your case could be heard in an hour or less. If not, how long are you estimating you need for trial? And then your mailing certificate. So you'd file this with the court and then provide a copy to the opposing party or their lawyer. Now let's talk about the list of witnesses and exhibits. Not every county requires this full list of witnesses and exhibits, but if you have trial exhibits, you will need to file those with the court, and it's nice to have a cover sheet with them that lists out each of your exhibits in order. So be sure that you file your exhibits with the court by the deadline set by the court and pursuant to the court's rules for submitting exhibits. So make sure you take some time and familiarize yourself with whatever that deadline is and calendar it. And then whatever the court's rules are for submitting the exhibits, you're going to want to make sure to follow those rules. So file your exhibits with the court by the exhibit deadline. Here's an example of the list of witnesses and exhibits. You would tailor this document by editing the parts in red to match up with your case. Here's where you'd list out your witnesses, and then here's where you could start listing out your exhibits. Now, if you're submitting hard copies of your exhibits to the court, and let's say you have an exhibit that's more than one page, you'll want to staple those together. Otherwise, there's going to be a lot of loose papers, which can be hard to deal with. So it's really important to organize all of your exhibits, staple individual exhibits together if they're more than one page. You can also put highlights on your exhibits if there's any particular information you want to, specifically highlight on a document. So this is a good time to not waiting until your exhibit deadline, but a couple weeks ahead of time, start preparing your list, start getting all of your papers organized, confirm exactly what the court's rules are for submitting your exhibits, and make sure you're complying with those rules. All right, then we've got this form called the Notice of Issues. This is under Rule 76.1F. The Notice of Issues must contain a complete list of all remaining contested issues the filing party intends to present at the trial. Issues not raised previously cannot be raised for the first time in the Notice of Issues. Each party must file a separate Notice of Issues. Issues listed in the Notice of Issues are listed generally. Specificity is reserved for the pretrial statement after the parties and or their counsel, if represented, have met and conferred to narrow or resolve the contested issues before the generation and submission of the pretrial statement. Neither party is required to file a notice of issues before a temporary orders hearing or other interim hearing. So this is going to apply before a trial, but not before a hearing on a motion for temporary orders. When do you file the notice of issues? It is due 20 calendar days before trial, and then the pretrial statement is due 5 business days before trial. Here is the set form for the notice of issues. Now, here in today's recording, we're talking about a modification or an enforcement case. So this is where you're going to be looking at these boxes here. Does your case involve modification or enforcement of legal decision-making? That would be box 5. 6 is, are you facing modification or enforcement of parenting time? How about modification or enforcement of child support, modification or enforcement of spousal maintenance? Are you looking at enforcement of the division of community property or debts, and or assigning or confirming separate property and debts? And then are attorney's fees at issue in your case? So you'll want to fill this out based upon what issues are contested and that are going to be heard at the trial. Can more than one box be checked? Yes, definitely. More than one box could be checked. If your case involves both modification and enforcement of legal decision-making, then you would check this box plus modification and enforcement. If your case just involves modification of parenting time, then you'd check this box here and then check modification of parenting time. So yeah, you can check more than one box. You just, the key here is to make sure that what you're selecting matches up with the issues that are going to be heard at trial. And then any other relief that you're requesting, you can list here. This is where you're going to date and sign and then fill out the mailing certificate. This document needs to be filed with the court 20 calendar days before your trial date, and a copy mailed to the other side. Let's look at the pretrial statement. A pretrial statement can be a joint or a separate statement. Unless the court orders otherwise, the parties may file joint or separate statements. If a joint statement has been ordered, or if you're in agreement to do a joint statement, then the party who initiated the case, so this is post decree. So the respondent could file a petition to modify. And if so, then the respondent would be the party that initiated the action set for hearing. Or it could be the petitioner that could seek a petition to modify. So it's whatever party filed the post-decree or post-order petition, they're the ones who would take the lead on the joint pretrial statement. And what they need to do is the following. They need to provide the other side with the outline of the pretrial statement 15 calendar days before trial. Now, the outline of the statement can be the set form that we're going to go through. You could provide that, a copy of the set form, to the other side 15 calendar days before trial. And then 8 business days or more before the hearing. That's when the parties exchange their respective portions so that the portions can be merged into one document. And then the final merged joint pretrial statement would be filed with the court at least 5 business days before the hearing date. If, however, the parties are self-represented and there's a history of domestic violence, then the parties must file separate pretrial statements. And then just a reminder of the timing, the notice of issues is due 20 calendar days before trial. The pretrial statement is due 5 business days before trial. The pretrial statement contains a lot of information, and this is all in the set form that we'll go over. So there's a description of the nature of the action, each party's name and address, if not confidential, the name and date of birth of each minor child at issue in the enforcement or modification matter, any stipulations or agreements the parties have reached, a list of any uncontested facts or law, a detailed and concise statement of the contested issues of fact or law, and then your position on each contested issue. If modification or enforcement of spousal maintenance is at issue, then the amount and duration of support sought. If parenting time is at issue, then what is the schedule of parenting time, including holidays and vacations, that you maintain is in the best interest of your child. Your list of witnesses you intend to call at the trial, If any depositions have unfolded during the case, then a designation of the deposition testimony you intend to use. Any objections you have to the other party's witnesses and the basis for each objection. A list of the exhibits that each party intends to use at trial, specifying exhibits that the parties agree are admissible, or if not in agreement, listing the objections and specific grounds for each objection that the party will make if the exhibit is offered at trial. A statement by each party confirming that all pretrial discovery and disclosure has been completed by the trial date, and that the parties have exchanged all exhibits and reports of experts who have been listed as witnesses. A statement as to whether the parties have in good faith discussed settlement, and if not, the reasons for not discussing settlement. Any request for attorney's fees, and then a statement of how a verbatim record of the trial will be made. You can just state there that the verbatim record will be made using the court's recording system, or you could list a court reporter if you've scheduled one to be there, or if the court's going to provide one. But generally, the verbatim record will be made using the court's recording system called the FTR Gold system. There's also certain attachments that you need to include with the pretrial statement. So if child support, spousal maintenance, or attorney's fees are at issue, you need to attach your affidavit of financial information. And then if child support is at issue, you need to attach your completed parents' worksheet for child support amount. So if you're looking to enforce child support, you would attach the underlying child support worksheet with the amount that was ordered that the other side hasn't paid. If you're looking to modify child support, then you would attach a worksheet with your proposed modified amount. Keep in mind that you are not allowed to present a witness or offer an exhibit during trial other than those listed and exchanged in your pretrial statement. The only exception to that is if the court orders otherwise for good cause. Also keep in mind that you waive the right to raise an objection at the trial or hearing if the specific objection to a witness, exhibit, or claim is not raised in the pretrial statement. A party may not present an issue not listed in either party's notice of issues at trial unless the court orders otherwise for good cause. So it's really important to make sure your notice of issues in your pretrial statement cover everything, because if they don't, you may not be able to use that. Okay, the question is same with spousal support. You don't do a worksheet for spousal support. There's a calculator that's coming out, but it hasn't been released yet. So you would not attach a child support worksheet related for a spousal maintenance issue. All right, let's look at the pretrial statement form. This is out of Maricopa County, and you'll see this matches up with what we just went over on the rules. So indicate whether you're doing a joint or separate statement, what kind of case the court is hearing, what's your trial date, who's your judge, how long the trial is going to take, the names and contact information of the parties, the date of service of the petition, the names of the minor children at issue in the case, if any. Your witnesses, there's going to be an additional document we'll go over in a bit where you can list out your witnesses. Your exhibits, we'll go over that document as well. And then the attachments, the affidavit of financial information, and then the child support worksheet if child support is at issue in your trial. Any stipulations or admissions, any uncontested facts, and then a detailed and concise statement of the contested issues of fact and or law, and then each side's proposed resolution of the contested issues of fact or law. And if these sections within this form don't give you enough room to list out all of this information, you can put it on an additional document and attach it. Whether or not pretrial discovery and disclosure has been completed, and then statements about settlement efforts, how the verbatim record will be kept, and then here's the mailing certificate for your form and where you would date and sign. So this document would get, once it's completed, it would get filed with the court and exchanged with the other side pursuant to that rule. So this is due the 5 business days before trial. Here's where you can list your exhibits, and you can, if you have more than 12 exhibits, then copy, do 2 of this document and change up these numbers. And then any objections that you have to the other side's exhibits, here's respondent's exhibits, any objections that the respondent has to the petitioner's exhibits. How would an attachment look like? An attachment is just an additional piece of paper where you have your information listed, and then you add that to the back of the document. Respondents' exhibits, and then petitioner's witnesses, respondents' witnesses. Preparing for trial. Now, this is the trial outline. The trial outline is not required under the rules. This is something that I use in my practice and that I recommend, because this is like your script to follow during the trial. You do not file this with the court. You don't exchange a copy with the other side. This is just for you to use, and it's optional, but I highly recommend it. So let's look at an example of a trial outline. If you're the petitioning party, this is where you would write in your opening statement, and then the petitioning party is going to go first. So this is where you're going to draft the details of what you're going to testify to. So assuming you're going to be your first witness, you don't have a lawyer, this is where you're going to list out everything that you want to talk about for the contested issues in your case. Would attachment have any format type rules? No, you can just essentially follow the format in the form. It's just if you don't have enough room in the form, then you can attach an extra sheet of paper to finish out whatever you want to include. So if legal decision-making is at issue in your case, if you or the other side, if you're requesting to modify that, then this is where you can explain what the substantial and continuing changes in circumstances are, and what you're requesting legal decision-making to be modified to, and why that's in the best interest of your children. If you've got an enforcement action for legal decision-making, this is where you can indicate what was the violation and what you're asking the court to do about the violation. If modification of parenting time is at issue in your case, what are the substantial and continuing changes in circumstances? What is your requested modification? And why is that in the best interest of your children? This is where you can incorporate in the exhibits you want to use. So one of your exhibits could be your proposed parenting plan, and this is where you can incorporate that into your testimony. If you've got a parenting time enforcement case, indicate how, what was the violation and what do you want the court to do about the violation. If child support's at issue in your case, if you've got a child support modification request, what are the substantial and continuing changes in circumstances that justify the modification? And what are you asking the court to modify child support to? And this is where you can incorporate your proposed child support worksheet as an exhibit. Also, you could present your affidavit of financial information, your co-parent's affidavit of financial information, and then explain each number used in your proposed child support worksheet. Where did you get those numbers from? Why are you asking the court to adopt those numbers? If you're looking for any changes to health insurance for the kids, medical expenses, or any other child-related expenses, you could explain that here. For the child tax exemption, if you're wanting that to be modified, explain your request. And then for enforcement, explain what child support hasn't been paid, what are the exact months, what's the exact amount that's overdue, and what are you asking the court to do about that unpaid child support. If you have a spousal maintenance modification request, what are the substantial and continuing changes in circumstances that justify the modification, and what are you asking the court to modify spousal maintenance to? You could present an affidavit of financial information as an exhibit. You could present, this should say the opposing party, not co-parent, but you could have your opposing party's affidavit as well. And then for enforcement, how did the opposing party violate the spousal maintenance provisions of your underlying decree? And what are you asking the court to do about it? For property division, if you're seeking enforcement of property division, then how did the opposing party violate the underlying order? And what are you asking the court to do about it? If attorney's fees and costs are at issue in your case, then explaining what your request is for attorney's fees, what each side's financial resources are. If you believe the opposing party has been unreasonable, you could explain that and what you're at and why, or if the other side's requesting legal fees and costs, why you object to their request. So you can tailor this to your case. And then to conclude your testimony, this is a good time to give the judge a summary listing out each thing you're asking the court to order to resolve your case. So again, this is a script that you would create and that you would read during your testimony. After you've testified, you'll be subject to cross-examination by the opposing party or their lawyer, and then you'll be able to testify one more time on what's called redirect once cross-examination is over to clarify anything that came up on cross-examination. How about therapy costs? That's where here, if you're asking for reimbursement for that, that would be in this section about child-related expenses. And so that would be part of that you would draft that request into this part of your trial outline. Okay, now keep in mind that the requests made in your everything that you're testifying to in here and the requests that you're making, this should already be established in your pleadings. So you're not going to be able to take the stand and testify that I want attorney's fees if you didn't already request that in your pleadings leading up to the trial. Or if it's not in your pretrial statement, if it's not in your notice of issues. So all of this needs to be tied together. You're not going to just be able to bring up new stuff in your trial outline as far as claims that you're making. Okay, once you're done testifying, if you want to call the opposing party to the stand, let's say you have an enforcement action and you want to call them to the stand to ask them questions about how they violated the order, then you could call them to the stand. Now, this is optional. You don't have to call them to the stand, but if that would help you prove your case, this is where you could draft your direct examination questions for that witness. If you have any other witnesses, you would want to draft direct examination questions for those witnesses. And then once you've presented all of your witnesses, which could be just you could be your only witness, then you would rest your case. And then it would be the responding party's opportunity to present their case. So you're going to want to prepare cross-examination questions for the responding party and their witnesses. And then you've got your closing argument. I do recommend that you start drafting your trial outline by drafting your closing argument, because that's going to help you see the big picture and help you with the presentation of the evidence. You don't have to start there, but I do recommend that. All right, let's look at the trial outline if you're the responding party. So if you're the responding party, then you're going to be drafting cross-examination questions for the petitioning party and their witnesses. And then once it's your turn to present your case, you're going to be presenting the points about everything that you want to testify about during your presentation. So again, tailor this to whatever issues are coming up in your case and fill out this document accordingly. So any other witnesses that you intend to present, draft questions for them, draft your closing argument. And again, your trial outline is just for you. You don't have to draft this, but this is a script you can use during your trial, and that can be really helpful. So this does not get filed with the court. It is not exchanged with the other side. This is just for you to use. Okay, so you've gone through your trial, and let's say that at the conclusion of your trial, the judge orders you to lodge a proposed order with the court's findings. You're wanting an explanation of who is the respondent? Well, when the underlying case is initiated, there's a petitioner and respondent, and those party designations remain throughout the case. But once you're post-decree or post-order, the responding party can petition the case, can file a petition as well, but they don't become the petitioner. They're still the respondent. They just filed the petition, and whoever filed the petition, they get to present their case first according to trial procedure. So that's why in the post-decree context, I'm referring to the parties as petitioning party and responding party, because the respondent could be the petitioning party if they're the one who filed the petition. Okay, so you're post-trial and the judge, let's say, has ordered you to file a proposed order for the judge to sign. So let's look at various types of proposed orders you could use. So there's a comment, it gets confusing at times. Yes and no. I mean, if you just keep in mind that petitioner and respondent always stay the same, then your caption isn't going to change. But you're going to know who filed the petition. You're going to know if you filed it or not, or if it was the opposing party. And whoever filed the post-decree or post-order petition, they're the petitioning party for that litigation, but they may be labeled as the petitioner or the respondent in the caption, depending on how that was whoever, initiated the divorce or whoever initiated the custody establishment case. So post-decree, a respondent can file a petition. They're still the respondent, but they're now the petitioning party for that post-decree or post-order matter, and they get to present their trial presentation first according to trial procedure. Okay, if you have a modification of legal decision-making, parenting time, and child support case, then the following papers are going to need to be filed post-trial if the judge has ordered you to lodge a proposed order. So there's the notice of lodging, there's the order modifying, there's the parenting plan that has the terms of the modified parenting plan, there's the child support worksheet with the modified amount of child support, there's the child support order that has the modified amount of child support, and then the income withholding order, which is the order to the person who's ordered to pay child support that goes to their employer and orders their employer to withhold a certain amount of child support from their paycheck so that that can go directly to the clearinghouse and then be given to the parent that's entitled to receive child support. So here's a notice of lodging form. This is out of Yavapai County. I didn't find one out of Maricopa County, but this is just a form that goes on top of your proposed order. And once this is all filed, the other side, the opposing party, has an opportunity to object to the proposed order if they think that something in there isn't accurate. Is lodging a legal term? Yes, you lodge a proposed order. Once it's lodged, that opens up the objection period, which is generally 10 business days and then 5 straight days for mailing. So you have that amount of time to object to the proposed order. If no objection is made, then the judge can sign the order and make it official, an official order of the court. So here's the court's proposed order modifying legal decision-making, parenting time, and child support. So this would be filled out according to the judge's findings and orders at the trial. And you can attach to this the parenting plan, the child support worksheet. Here is the proposed order modifying parenting time and or child support. So if legal decision-making didn't get modified and only parenting time did, you could use this form. Or if only parenting time and child support were modified, you could use this form as well. And then if you have a modification of child support and or spousal maintenance, here's a form to use just for child support or spousal maintenance. And then here's where you could put the terms of the modified parenting time if parenting time is modified, and this could be attached to the proposed order. So you'd fill this out with whatever the court ordered for the modification of parenting time. And then child support worksheet, if child support is being modified, this would have the numbers that the court ordered for the modified parent or child support, and this would be attached to the proposed order. And then the child support order, this would be a separate document. This is not attached to your proposed order. This is another document that's filed contemporaneously with your proposed order. And then in Maricopa County, there's this current employer information form. This would be if child support was modified or if spousal maintenance was modified. And in Yavapai County, we use this income withholding form, and a lot of other counties use this as well. So this would get filled out and filed with the court as well if there's a modification of child support and or spousal maintenance. Let's look at the proposed order enforcing legal decision-making and or parenting time. So we just looked at the documents for modification, and now this is for enforcement. Can I change the county of the form and use it in my county? Yes, of course. A lot of self-represented parties do that because Maricopa County has some of the most comprehensive forms in their database, but not everybody's in Maricopa County. So people just cross out the county and write in the name of their county. Here's the proposed order enforcing legal decision-making and or parenting time. See, this said Yavapai County and I whited it out. So this is where you just type, write in whatever county your case is being heard in. And then if it's only legal decision-making, you could check that box. If it's only parenting time, you could check this box. If it's both, you could check both boxes. And then you'd fill this out according to whatever the court ordered and found at your trial. Here's a proposed order enforcing support. So enforcement of child support, enforcement of child support arrearages, enforcement of medical insurance coverage, enforcement of spousal support, enforcement of medical, dental, or vision costs, and then enforcement of other sums owed pursuant to a child support order. So this is, again, I whited out Yavapai, and you could add in the name of your county here. Here's a proposed order terminating child support and or spousal maintenance. So if your child has emancipated or spousal maintenance ends, here's a proposed order that could be used for the termination of those obligations. And then a proposed order stopping the order of assignment or the income withholding order. So there needs to be an order that ends that order to the employer for the payer of the spousal maintenance or child support, telling them, hey, look, you don't need to take that money out of the payer's paycheck anymore and send it to the support clearinghouse because the obligation has ended. So here's the proposed order stopping order of assignment or the income withholding order. What if you have a case about the enforcement of the division of property from your divorce? Here's a form for an order enforcing decree regarding division of property. Okay, and that brings us to the end of today's presentation. So just as a summary, when preparing for trial, if you need to get your case set for trial, you can use the motion to set form. You'll want to create your list of witnesses and exhibits and start, compiling your exhibits to submit to the court. Make sure that you're aware of and comply with all of the court's rules for submitting exhibits, and make sure that you submit them by the exhibit deadline. You've got your notice of issues that's due 20 calendar days before trial. You could do a joint or separate pretrial statement depending on whether or not the court orders joint or separate. And that's going to be due 5 business days before trial. The trial outline, which is optional, it's not filed with the court, it's not exchanged with the other side, but this is a script that you can draft for you to follow during your trial. And then the notice of lodging and proposed order, if the judge orders you to draft a proposed order and file it with the court. All right, thank you so much for attending this lecture. If you have any questions, please bring those to the Q&A.